This is Left Voices for Wednesday, March 19th, 2014. I'm Andrea Sears. Tonight,
we need a contractor that has this much control over our affairs to be held accountable for what is one of the worst atrocities in American history.
10 years later, victims of torture at Abu Ghraib Prison are still seeking justice. Next month marks the 10th anniversary of the release of photographs showing extreme abuse and torture of prisoners by U.S. military personnel at Abu Ghraib Prison in Iraq. The graphic images shocked the world. They showed men stripped naked, tethered on leashes like animals, sexually humiliated, threatened by menacing dogs, hooded and wired to electrodes, beaten and bloodied. Some appeared dead. Several low-level enlisted personnel were court-martialed and sentenced to prison for the abuse. Military investigators had concluded that interrogators from CACI Premier Technology, a private company under contract to the U.S. government, had directed soldiers to commit sadistic, blatant, and wanton criminal abuses of the prisoners to soften them up for interrogation. In 2008, citing violations of federal and state laws, attorneys from the Center for Constitutional Rights filed a lawsuit, Shamari versus CACI, on behalf of 4 Iraqi men who were victims of torture at Abu Ghraib. After years of delay, that lawsuit was dismissed in June of last year. But on Tuesday, lawyers for the plaintiffs were in a federal court of appeals in Virginia arguing for the reinstatement of that lawsuit. Jeena Shah is an attorney working on the case with the Center for Constitutional Rights as cooperating counsel.
Last summer, Judge Lee in the Eastern District of Virginia had dismissed the case entirely, saying that a recent Supreme Court decision had actually made the claims inoperable because they were committed outside of U.S. borders. Had also dismissed the state law claims, which were assault and battery, et cetera, apart from just the torture and the war crimes, on other legal and technical grounds, without ever having decided the merits of their claims, without ever having reviewed the facts of what the plaintiffs have alleged. And so once the case was dismissed, we had the opportunity to file an appeal before the Fourth Circuit Court of Appeals, and yesterday was the hearing on our appeal.
The Supreme Court case was the Kiobel case. That was Kiobel versus Royal Dutch Shell, correct?
Yes.
So that was a foreign plaintiff suing a foreign corporation in a U.S. court under the Alien Torts Claims Act. How does this case differ from the Kiobel case?
As you correctly described, it was a foreign corporation alleged of aiding and abetting a foreign government for acts committed abroad in Nigeria. And what we have here is an American corporation domiciled in the U.S., in Virginia, who we allege conspired with members of the U.S. military, low-level military soldiers, to commit abuses at a U.S.-run detention center in U.S.-occupied Iraq. So unlike the Kiobel case, where almost all of its facts were foreign, here we have a plethora of ties to the United States.
Did the Supreme Court, in its Kiobel ruling, make provisions for times when the Alien Torts Claims Act may be applied?
Yes. In the last part of its opinion, the Supreme Court explained that on the facts in Kiobel, where everything was foreign, that would not be able to go forward. But where claims, and the Supreme Court used these words, touch and concern the territory of the United States with sufficient force, those claims can move forward. Now, defining what sufficient force is the work now of lower-level courts. And we feel that the work in this case is actually quite easy because every part of the claim that plaintiffs are bringing is tied to the U.S. military, and to a U.S. corporation.
This is also a case where there have been criminal convictions under U.S. courts-martial. Lindy England and Charles Grainer, as I recall, were among those who were convicted. What are the circumstances, and how does that change things?
Others were also convicted and sentenced, some as high as 10 years. And actually, two of those who have been convicted, Charles Grainer and Frederick, both testified that they received orders by CACI interrogators to torture and abuse these plaintiffs in order to, quote-unquote, soften them up for interrogation purposes. So what the plaintiffs are arguing here is that their co-conspirators, Grainers, Fredericks, England, their co-conspirators have got off scot-free. They've actually profited from their contract with the U.S. government and have continued to enjoy billions of dollars in contracts with the U.S. government, whereas these low-level military police officers were court-martialed, were sentenced, and their names are ingrained in everyone's memory as associated with the horrific acts that occurred at Abu Ghraib.
At the time, was there a provision under Iraqi law or occupational law that gave U.S. contractors immunity, and does that affect anything here?
That actually was one of the issues in the case, apart from the claims under the Alien Tort Statute, which is federal law, so the claims of torture and war crime, and there was also some claims under state law, assault and battery, and other such claims. And so what happened there was the lower court actually decided that, well, because the contractors were working in Iraq, which at the time was governed by the Coalition Provisional Authority, and the Coalition Provisional Authority, the court decided, had given blanket immunity to U.S. contractors. Now, we find the reading of the lower court to be completely misguided, and that's one of the issues that we argued yesterday before the Court of Appeals. The Coalition Provisional Authority law says that contractors and those working with coalition personnel, any claims brought against them should be brought back to their sending state. Here, that would be the United States. And the way we deal with claims of torture and abuse, in addition to criminal prosecution, is through civil lawsuits like the one the Shamari plaintiffs have brought. So it is completely in line with the text and the purpose of the law under the Coalition Provisional Authority that was governing Iraq at the time.
Are the military contractors being directly accused of perpetrating torture and abuse or directing it?
The claims are primarily centered around their direction of the torture and abuse. While there is some evidence in the record to suggest that CACI interrogators themselves had participated in the abuse, the claims primarily stem from their direction of U.S. soldiers to commit this abuse.
Was their direction specific as to what should be done to, quote-unquote, soften up these prisoners for interrogation?
Yes, actually, the military police officers who were court-martialed testified the same exact techniques that the plaintiff suffered from, which includes a list of techniques that have been found individually and together to constitute torture. The same techniques that the plaintiff suffered from are the same ones that U.S. soldiers have testified that CACI interrogators ordered them to commit.
How did CACI attorneys respond in court yesterday?
They stayed firm in their narrow position that human rights violations that occur abroad are now precluded by Kiobel, which directly contradicts the holding of Kiobel. And they also stood fast in their theory that this actually affects a political question. They have turned it around, suggesting that we are actually questioning military orders. They suggested that the military ordered them to commit torture when we, in fact, have alleged, as was shown through military investigations, that there was a command vacuum at Abu Ghraib, and CACI exploited that command vacuum and took advantage of this and ordered this torture. So whatever the fault of the U.S. government may be in this, it is not at play in this case, so it should not be dismissed as a political question.
And is there any criminal prosecution available here? It just seems on the face of it that what happened at Abu Ghraib was a violation of international law as well as U.S. law.
Yes, actually, we've been calling on the U.S. government to prosecute CACI for years. It is incumbent on the U.S. government. CACI not only violated U.S. international law, it also violated the terms of its contract by doing so. And the U.S. government should be going after CACI and prosecuting it, but it hasn't done that. As to whether or not any prosecution could happen at the international level, given the U.S.'s refusal to accept the jurisdiction of the International Criminal Court, and also the fact that CACI is a corporation, that makes those questions a little bit unclear. But what is clear is that the U.S. has a responsibility and is able to prosecute CACI for these crimes. It's been 11 years to the day since the invasion of Iraq, and next month it'll be 10 years since we first saw the photos coming out of Abu Ghraib. And we have CACI, who continues to profit billions of dollars off the U.S. government, and we need to hold it accountable. We need a contractor that has this much control over our affairs to be held accountable for what is one of the worst atrocities in American history.
Jeena Shah works with the Center for Constitutional Rights as cooperating counsel in the case Al-Shamari versus CACI. This has been Left Voices for Wednesday, March 19th, 2014. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.